Delhi. Today we will discuss about one of the most important chapter of the business law, that is the Indian Contract Act 1872. What is contract? As per section 2H of the Indian Contract Act 1872, an agreement enforceable by law is a contract. Means enforceability is the most important part for converting any agreement into contract. Here it is also clear that there are lot many types of agreement, but all those agreements cannot be converted into contract. So we will discuss in next slide what those agreements are. When we discuss agreement in broader term, agreements may be of the social nature, may be of domestic nature, may be of the legal nature also. But as we discuss in the definition of the contract, the agreement having legal nature will mount contract, nothing else. So when we talk agreement in general, it can be defined as every promise and every set of promises forming or not forming consideration for each other party is called agreement in general. Here one new word has been used in this definition, that is consideration. Consideration is one of the very important word used in the legal world. Consideration means something in exchange of, something in lieu of. When we pay money and purchase milk, so paying money is consideration for milk sellers, and milk is consideration for me who is paying to purchase milk. Means one or other, payment is in lieu of milk, milk is in lieu of payment. Now, after discussing the broader term of the agreement, we will discuss that part of agreement which mount contract. Contract Act has defined it as per section 2E. The term agreement is defined as every promise and every set of promises forming the consideration for each other is called agreement. Now, we need to know what does promise mean. Though everyone knows what is promise, but in law, in Contract Act, promise has been defined for better understanding, for better interpretation of the Act. Section 2B defines the promise. Proposal or offer of one party accepted by other is called promise. When I propose to milk seller, take money and give a liter of milk, this is my proposal. The milk seller may accept or may not. Or in other way, if milk seller offer me a liter of milk for rupees 60, I may accept or I may not. Once either my offer is accepted by milk seller or the offer of milk seller is accepted by me, it takes form of the promise or set of promises. Again, one new word has been used, and that is one of the most important word, that is proposal or offer, which in details, though we will discuss in later part of this chapter, but in next slide we will discuss the definition of proposal and offer. Section 2A of the Contract Act says willingness to perform certain action of doing or abstaining from doing if other party accepts is called proposal. So proposal is nothing but willingness of one party to perform certain action or even abstain from doing. What does abstain from doing means? Suppose I request my neighbor, please don't erect this wall. It will make the movement of my car easy and take some money in against of that. My neighbor may accept or may not. But my willingness is here not to do any act by my neighbor or other party, but to abstain from doing, abstain from erecting wall. So this type of willingness to perform is also called proposal or offer. So we can say now that in contract, these three terms are important: agreement, of course, enforceable by law; promise; and proposal or offer. Concept of these three terms are important to understand the contract in details later on. Here, whatever we have discussed till now, a diagrammatic representation of contract, agreement, promise, and proposal. Here it is clear that proposal is the biggest ambit. Right from morning to night, we used to propose or offer or show our willingness to other. Why don't we do it? Why don't we do this and that? Either against consideration or without consideration. All those willingness to perform certain action of doing or abstaining from doing by other party is proposal, and this is the biggest ambit. Out of these maximum proposal what we have in our life, some proposals are converted into the promise. Those proposals which are accepted by other party are the promise. But all these promises do not convert into the agreement. Only those promises which have some scope of consideration, something in lieu of. If I promise someone, so the other party or that someone is also required to give me in lieu of, in exchange of. If I purchase milk, I am paying money, so I need to have milk from the party. The milk is in lieu of. Without consideration, this promise or set of promise, though will mount agreement, but that agreement will be of social and domestic nature. That agreement will not be enforced in the court of law. And here we are discussing about those agreements which are enforced in the court of law. So we have lot many agreements, but all those agreements are not converted into contract. Only those agreements are converted into contract which are enforceable by law. So in other words, This diagram says that all contracts are agreement, but all agreements are not contract. All agreements are promise, but all promises are not agreement. All promises are proposals, but all proposals are not promise. Thank you. Thank you very much.